got the jail calling in for an arraignment, I think. All right, good morning. What is your name, sir?
My name is Jerry Grove II, Your Honor.
All righty. All right, so good morning. We've started now the public access online as well as in the courtroom. We're in the 53rd Circuit Court for the County of Presque, and we're calling first up from page 1, People of the State of Michigan versus Jerry Grove, file 21-93174FH. We've got Mr. Grove present from the Presque County Jail by video. His attorney, Mr. Gilbert's in the courtroom, as is the prosecuting attorney, Mr. Radsbon. Mr. Gilbert, this is the time and date set for an arraignment.
It is, Your Honor.
Has Mr. Grove been provided with a copy of the information?
Yes, Your Honor.
Would you like the allegations read?
We'll waive the reading.
And how does he wish to plead to those allegations?
He's going to stand mute, Your Honor.
We'll enter a plea of not guilty on his behalf then. And is a forensic center referral requested?
Your Honor, we've already requested one, and Mr. Grove has passed that, so we will not be requesting
Okay.
one at this time.
It looks like through an anomaly of some scheduling issues we have, our August date is August 2nd. That's 3 weeks out. So our September date, though, is September 13th. You want a docket call September 13th then?
The docket call September 15th would be fine, Your Honor.
Okay, we'll schedule this then for docket call September 13th at 10 a.m. I'll schedule that to be held in person, but just like we did before the pandemic for all but sentencing hearings, the jail can always zoom in, you know.
Thank you.
Estimated length of trial?
2 days, Your Honor?
No more than 2 days.
Okay. Anything else for purposes of scheduling, counsel?
No, Your Honor, thank you very much.
Okay. All right, Mr. Grove, you have a good day, sir.
You too, Your Honor.
And what is your name?
My name's Justin Pettit, Your Honor.
All right. This case is from page 2, People of the State of Michigan versus Justin Pettit. It's file 21-93176FH. And we have Mr. Pettit from the Presque County Jail by Zoom. His attorney, Mr. Vogler, is with us in the courtroom, as is the prosecuting attorney, Mr. Radsbon. Mr. Vogler, has Mr. Pettit been provided with a copy of the information?
He has.
Would you like the allegations read?
No, we talked about it this morning, and so we're going to waive that.
Okay, we'll enter a plea of not guilty on his behalf then. Is a forensic center referral requested?
It's not.
Estimated length of trial?
I would say a day. We could get this in a day.
Okay. Docket call on September 13th, Mr. Vogler?
Yes, that's fine.
We'll schedule it for September 13th at 10 after 10 in the morning. Anything further on this file, Mr. Vogel?
No,
Mr. Radsville?
nothing further. Thank you, Judge.
Okay, Mr. Pettit, you have a good day too, all right?
Thank you, you too.
Not here for now. Let me see, we've got somebody. Well, I want to see who this phone is.
Looks like Mr. Cole to me.
There's a Mitch James in the waiting room, but I'm not sure who.
Yeah, no, I'm thinking that's Mr. Cole.
Morning, are you Mitch James?
Yes, I am.
What case are you here for, sir?
Caitlin Lucas.
Oh,
Okay,
all right, that's good. He is a victim in that matter, Judge.
okay. All right, I just want to affiliate you with that case, and then I'll place you back in the waiting room momentarily, Mr. James, okay?
Thank you.
All right. We'll rename him, but he's having trouble with his audio. Put him in the- Take Mr. Blair. So this will be from page 3. We'll take next, People of the State of Michigan versus Devin Blair, file 17-93010 FH. So take Mr. Blair's case now. All right, so Mr. Blair, you're here in our courtroom with your attorney, Mr. Vogler, for sentencing on a probation violation. Have you had a chance to review the probation violation recommendations with him?
Yes, sir.
All right, Mr. Vogler, do you have any additions or corrections to the information contained in that report?
Well, yes, under the evaluation plan, I guess that's the largest paragraph there that we see
Okay,
on the page, where there's a description of police spoke with some witnesses. One said the party had been going on for 3 days, and there had been talk amongst the partygoers of fighting each other. Another witness says they were calling her uncouth names and it threatened her, and she was scared to death. So I guess the upshot of my reading that is just that Mr. Blair had arrived. He'd only been there 1 day, and he didn't want, I guess he doesn't want guilt by association with regard to what's being said there. Some people may have been doing that, but it wasn't him.
Well, do you have a particular recommendation about the language in that report, or is that just to clarify? I mean, I understand what you're saying, and when it says they were calling her uncouth names and had threatened her, I don't take that to mean that we know who it was, or that I'm not holding Mr. Blair accountable for those names or threats, because I don't know if he's the one that made them or not. But is there any change in the language you wish to propose, or did you just want to make sure that I understood that the same way you did?
Yeah, I just wanted to make sure you understood.
Okay, and thank you. That I think that's a valid point to make.
I think that's it, Your Honor.
Okay, Mr. Radsbon, any additions or corrections to the information in the report?
No additions or corrections, Judge.
Okay. And Mr. Vogler, anything you'd like to say on behalf of Mr. Blair?
I recognize Mr. Blair currently charged with resisting, assaulting, obstructing, and a disorderly conduct. He firmly has pled not guilty with regard to those charges, and at this point, he intends to go to trial on those. What's that? Well, at any rate, he does have some mental health issues. I think that's brought out in the report. He's never really had any good treatment with regard to those. So I guess on the positive side, with regard to this, he did stay out of trouble for a few years here until the end. Sought employment, got employment, worked, and I think that's what he intends to do when this is behind him.
Okay, thank you, Mr. Vogler. Mr. Blair, you're not required to make a statement at your sentencing, but it is allowed. Is there anything that you wish to tell me or no?
No, sir.
Okay. Mr. Radsbon, any recommendations from the people?
Yes, the judge initially, in terms of an initial period of incarceration, I would ask for the 9 months as opposed to 7 months. Mr. Blair was on probation with this court and quite frankly just took off. I was gone for almost over 3 years. In addition, a period of probation, total I would ask for 2 years.
All right, well, Mr. Blair, you're here for sentencing on violating your probation. You were on probation for a possession of drugs case. You were placed in the Swift and Sure sanctions probation program, which would give you an opportunity to address, some of the things your attorney mentioned and do so in a way that keeps you in the community. But it sounds like you never really started that program. That was back in 2018. I wasn't the initial sentencing judge on that. And am I reading that right, that you never really even started that program?
Yes, sir. I drug tested like once or twice, and then I honestly have shy bladder. I tried to be, I had like my muscles tighten up. It wasn't really the problem of not smoking pot or drinking alcohol. It was just that, and then I had an opportunity to go get a job, and so I ended up leaving.
Okay. And then you went down to Florida for a job down there. Okay. All right. So you absconded from your felony probation. And then it's like 3 years before you end up back in the court. You come to Michigan about 8 months ago. You're working. So those are good things where you're, holding down a job, but you're still ignoring the fact that you've got this felony case out there. Probation is something that courts have done for well over 100 years instead of sending people to jail or prison to use probation. And you took that as a blank check to just live life the way you wanted to without, like you almost didn't have a court case. So obviously probation doesn't work for you, so we're going to revoke your probation, remove you from the Swift and Sure Sanctions program, obviously. And so now I'm left with the only other tool in the toolbox is how much jail to give you. And the guidelines at the initial sentencing were 0 to 9 months. Your absconding on probation would certainly be grounds to exceed those guidelines. But the initial charge of the possession of the Xanax is not, among the worst cases that we see. So I'm not going to exceed those guidelines, but certainly just skipping out on court, and living life the way you want for 3 years means you're going to be at the top end of those guidelines. So I'm going to revoke your probation, sentence you to 9 months in the Presque Isle County Jail, and give you credit for 63 days that you've served previously. The fines and costs that were previously assessed, including restitution, it looks like you haven't paid a penny on those. Those are still due and owing. And when you're released, you got to make payment arrangements, or we're going to bring you back and throw you in jail for.
Money to put down whenever.
Well, you had money the last 3 years and didn't do anything about it, so I really don't trust you right now. So you'll have to show me. Otherwise, we'll bring you in and give you 90 days jail for contempt every time you don't pay. All right, so Mr. Blair, you've got the right, or you've got the option, if you wish, to file an application for leave to appeal to the Michigan Court of Appeals to challenge your the sentence on the probation violation. So we're going to get you a copy of your appeal rates for probation.
I'll have to print them.
Okay, we'll have to get those to you. We're going to send you a copy of your appeal rights. One copy we're going to ask you to initial and give back to us. One is for you to fill out if you wish to appeal. If you can't afford an attorney, we would appoint one for you within 42 days. If you asked us within 42 days of today's date. You have any questions about that, sir?
No, sir.
Okay, good luck to you.
Thank you.
Mr. Cole. Send Mr. Cole a message. Have him call back in, see if he gets those prompts. Mr. Vogler, if you have any contact with Miss Lucas, because that's up for an arraignment, but I don't see her in the waiting room.
No, not recently. I mean, the last time I had spoke to her, she was in Clear County Jail.
Okay.
So she was released June 18th, I believe, from there. I know we sent a notice of the arraignment and the information to an address in Mount Pleasant. In addition to.
We have Rose to come, or ever come from us.
We also sent it to the Clear County Jail, so. It could be, maybe she's been, she had something outstanding in Midland, but my understanding was that was a 14-day thing that should be over with by now. So.
Okay. All right, well, we're here for an initial arraignment on that case. Lucas 21-93173FH. It's scheduled for 9 a.m. We have the complaining witness in the Zoom meeting. We were allowing Ms. Lucas to report by Zoom. Council reports that she was in another county's jail. Reportedly, she's been released and he hasn't had contact with her. This is the first non-appearance in this file since it's the initial arraignment. Mr. Radzavan, any request from the people?
Yes, Judge, I'd ask that her bond be canceled and potential warrant be issued for her arrest.
All right, well, I might be inclined to do that, but I think the new criminal justice reforms would prevent me from doing so. This being the first failure to appear in the case.
In this court, it's the first. It's not her first failure to appear, though.
in this case, in the
No,
district court?
In other counties.
Sure, yeah, the way the law says it's in the case. So what I can do is, we're back here on August 2nd. What I'll do is we'll do a show cause for August 2nd and continue the arraignment to that date. For 9:10 a.m. And we'll require her to appear in person. If she doesn't appear at that date and time, we'll issue a warrant. Mr. Radsbon, is your office able to prepare a affidavit for show
I'll have
cause?
them do that.
Okay,
Get you to sign.
okay, thank you. All right, Mr. James, sorry, Ms. Lucas isn't here today, so we're gonna give her until the next court date, August 2nd, to appear and explain why she wasn't here today. If she's not here, then we'll issue a warrant for her arrest. Okay. All right, have a good day, sir. All right. What's your name, sir?
Brian Brown.
Okay. Got lost Mr. Gilbert here. I do see the prison in the waiting room too, so we can take that case. Where's?
Gilbert's either in the hall or in the office. I saw him. There he is.
All right, Mr. Gilbert, I do see the prison here for Mr. Chapman.
Excellent, ready to go.
Are you Mr. Chapman?
Yes.
All right, so we'll call from page 4, the case of People of the State of Michigan versus Wyatt Chapman. It's file 20-93165FH. And we have Mr. Chapman present with us from the Michigan Department of Corrections by Zoom video. His attorney, Mr. Gilbert's present in the courtroom, as is the prosecuting attorney, Mr. Radsabon. We're providing public access both in the courtroom and online. And Mr. Chapman, you would have the right to be physically present in the courtroom for your sentencing. Do you wish to exercise that right, or would you like to waive it and be sentenced on video here today?
I'd like to waive it, Your Honor.
All right, and have you had a chance to review the pre-sentence recommendations with Mr. Gilbert?
Yes.
All right, Mr. Gilbert, do you have any additions or corrections to the information contained in that report?
Your Honor, I did discuss this with my client. I was able to get it to him, and him and I did talk via telephone. We have no additions or corrections, Your Honor.
Okay, Mr. Radsabon, any additions or corrections?
No additions or corrections, Judge.
Okay, the advisory guidelines range is scored at 10 to 23 months. Any scoring challenges, Mr. Gilbert?
Your Honor, I reviewed that, and I have no challenges to the scoring.
Mr. Radsabon?
No challenges to the scoring, Judge.
Okay, Mr. Gilbert, anything you'd like to say on behalf of your client?
You know, yes, I didn't mean to say I meant to say, Your Honor, we did have a agreement in this case, I believe, to a 6-month jail sentence. And in light of my client's situation, we don't want to adhere to that. We'd ask the court to consider a prison recommendation. The reason for that, then that would remove any option. I mean, that's what he'd be sentenced to because he was on parole at the time of this offense. I would point out, though, that I do believe he has some comments for the court. I would point out, though, MDOC picked him up in February. I believe it was February 8th. Prior to that, he sat in the county jail since fall. With the COVID lockdown, that did not work well for my client. I believe he's approaching 8 or 9 months of incarceration already. We'd ask the court to take a middle range of the guidelines and possibly consider 15 months. I'm hoping that he does get credit from February when he was taken into MDOC. Thank you very much, Your Honor.
Thank you, Mr. Gilbert. Mr. Chapman, is there anything that you wish to say, sir?
Yes, Your Honor.
I'm here today because I made a mistake and I accept full responsibility for my wrongdoings. But I'm much more than you see on paper. I'm not a meth dealer or a meth user. I had enough ecstasy for one-time use. Ecstasy can only be used at most once a month to feel the full effects, which last 6 hours. I'm not justifying my use, just saying there's a big difference between the two, and I wasn't out using meth, binging for days or weeks like so many others. It is an evil drug that is ruining the world along with countless lives. But I was wrong, and I wish I could take it back. I've struggled with different substances for a long time. I've come a long way from daily opiate dependence and haven't used opiates in over 3 years. I battle with depression, anxiety, and PTSD. I'm still learning to cope. My family and I have experienced much trauma and loss. My brother passed away in 2017. My younger brother. My daughter's mother, who was a meth addict, took her away from us out to North Dakota, cutting us off from all contact, telling us we will never see her again. I'm legally powerless and at her mother's mercy because she was born under wedlock to a man who committed suicide and can no longer sign her rights over to me. She used my love for my daughter against me for 6 years, and all this has taken a serious toll on my mental health. We miss my little girl and her little sister dearly and fear for them every day. We've been there for them through so much. I'm a good dad and my kids absolutely adore me. My son, who is so used to having me around, misses me and constantly talks about me. I cannot even express how much it hurts having my girl ripped away and being locked away from my boy for so long when all I want is to be a father, protect them, and be a part of these precious years. They're so beautiful and intelligent. They mean the world to me, and I miss them terribly. They need their dad. I'm turning my life around. There are so many people who believe in me. I'm fortunate to have such a big family out there waiting for me to come home and enjoy life with them. It's very hard to know I've let them down, and I'll never allow this to happen again. They deserve better. I'm not a drain on society. I'm a hard worker who's always held down a job. Cooking is my passion, and I would like to someday open my own restaurant. I have productive hobbies to spend my time doing with my family, like gardening, raising livestock, and fishing. I will find a good counselor who can help me work through and understand my addictions and anger. That night wouldn't have happened the way it did if it wasn't for my alcohol abuse. My failures are a direct result of my addictions. I'm ready to put this all behind me and move on. I'm so tired of suffering and letting these things control me, and I will utilize all the help I can get. I know I can do better. I'm a good person with a good heart. I'm genuinely sorry for what I've done to my kids, my family, the community, the court, and to Madison. Violence is completely out of character for me, and I feel so ashamed and truly remorseful for my actions. I'm going to keep working on myself, continue my recovery, abide by the law, and avoid anything that could risk my freedom and success. Since I'm not yet sentenced for my parole violations, and getting sentenced to a prison term today would make my violations go away, I'm told it's therefore possible to get credit for the 5 months I've been in the MDOC. So today I would ask that you please consider the 9 months I've already been incarcerated and give me a lighter sentence in the MDOC. Life's too short and I just want to go home and start over. This is the hardest and longest time I've done, and honestly, I've learned my lesson. It's changed my whole demeanor and outlook on life, and I'll never be the same or forget this awful experience. I know what I must do differently, and I'm done with my old ways.
Thank you, Mr. Chat.
Thank
Mr.
you.
Radsbon, recommendations from the people?
Your Honor, we did agree to a 6-month county cap. And we will hold to that. Of course, it would be consecutive to when he is released from prison on his current term. But we'll leave that up to the court's discretion.
Okay, thank you, Mr. Radsbon. Well, Mr. Chapman, any sentence I give today is required to be mandatory to any sanction on the parole violation. You were on parole at the time of this offense. I hope that, it sounds like you understand that, you're being sentenced today for possession of a dangerous drug. And I hope you understand that it's a lot more than just possessing and using a drug that gives you some euphoria or some energy or some reaction in your brain that you desire. It causes you to act in ways that now you are ashamed of, that you acted violently toward people that you care about and uncooperatively to the police. And that's not, sounds like that's not who you want to be. So I hope that you draw the right lessons from that perhaps these drugs are not helpful to the life you want to live. You want to enjoy time with your family. You want to pursue your culinary passions. Illegal drug use is not going to help you do any of those things. You've got 4 prior felonies. You were on parole at the time. So I'm not going to follow the sentence agreement for the 6-month county cap. I would sentence you to 15 months minimum in the Michigan Department of Corrections would be my intention. Mr. Gilbert, you've had a chance to review that with Mr. Chapman. Does he wish to withdraw the plea or go forward with that sentence?
We would go forward with that sentence. Thank you, Your Honor.
All right, so Mr. Chapman, you understand because I'm not following the plea agreement, you would have the right to withdraw that plea. I'm supposed to tell you what my sentence would be to allow you to decide. So my sentence would be, if you want to go forward, the Michigan Department of Corrections for 15 months to 10 years with no credit because it's consecutive to parole. Do you wish to withdraw your plea or go forward with the sentence?
I wish to go forward with the sentence, Your Honor.
All right, Mr. Chapman. Well, taking all those things into account, it would be the sentence of this court that you would be committed to the custody of the Michigan Department of Corrections for a term of not less than 15 months nor more than 10 years. There's credit for 0 days served because it's mandatory to parole. And there's state costs of $68 and crime victims' rights assessment of $130. And Mr. Chapman, if you wish to appeal, you'd have to file an application for leave to appeal. If you couldn't afford an attorney, we would appoint one for you at public expense if you make that request within 42 days of today's date. So we're going to send you a copy of those appeal rights and ask you to initial one for return to us so we have it in the file that we know you have those rights. The other one is for you to fill out if you do wish to appeal. This is a sentence within the guidelines, and I do understand if the DOC decides not to impose a prison penalty on the parole violation, perhaps you'll end up getting some credit on this, but this will be mandatory consecutive to whatever they do. All right, any questions, Mr. Chapman?
No, Your Honor.
Okay, good luck to you, sir.
Thank you very much, Your
Thank
Honor.
you.
Good luck, Mr. Chairman.
Thank you, Mr. Gilbert.
Well, Mr. Cole has not called back in, so let's go ahead and handle from page 4, People of the State of Michigan versus Brian Brown. It's file 19-93115FH. Mr. Brown, you're here for sentencing on violating your probation. You were on probation to this court for a misdemeanor, a 1-year misdemeanor of malicious destruction of property. Mr. Gilbert, have you had a chance to review the probation violation report with Mr. Brown?
We did, Your Honor.
Do you have any additions or corrections to the information in that report?
The only thing that my client wished me to point out was in the evaluation and plan, the second paragraph, there's a sentence that says that he has since moved in with a convicted felon. He just wants you to know that the probation officer knew that. That was not something that he did without fully disclosing that to the probation officer.
Okay, and that, I mean, he's not, that wasn't, doesn't constitute a violation for which he's here then. Okay. All right, Mr. Radzabon, any additions or corrections to the report?
No additions or corrections to the factual content, Judge.
All right, and this was a misdemeanor for which Mr. Brown was on probation primarily for restitution, which he's paid. So there are no guidelines range. Mr. Gilbert, anything you'd like to say on behalf of Mr. Brown?
Well, the court identified pretty much my main argument for the sentencing or allocution is that the primary purpose of his probation was to pay back the substantial sum of what that first case was about, which he has done, and made the victim in that case whole by the replacement of the trailer. There was a tow trailer that he completely has taken care of the restitution. Furthermore, he hasn't been sentenced in Sheboygan County on the underlying offense yet.
Yeah,
We did go through sentencing. I apologize, Your Honor, and there was no jail time associated with that. I do believe that has to do with the new guidelines. And we'd ask that the court, follow basically that if and not give him any jail time if he doesn't get it on the major offense. The court to take that in consideration, and I see where they want him off probation, but he has accomplished the main goal there, and consider no additional jail. Thank you.
Okay, thank you. Mr. Brown, it's not required that you would make a statement, but it is allowed. Is there anything that you wish to say?
well, I know I messed up in life and just want to get through this and continue on in life without using alcohol and just making good decisions.
Okay, thank you, Mr. Brown. Mr. Radsbon, recommendations from the people?
Your Honor, we believe a short period of incarceration would be appropriate. I'm asking that you impose 14 days jail credit for 2 days service.
All right. Well, Mr. Brown, you've made a fairly simple matter much more complicated for us here. Looks like back last summer, you were in here for sentencing on a charge of destruction of property, punishable by up to a year in jail. And it had involved, I think it involved alcohol. It was an argument at a bar, and I think alcohol was involved with that. And we put you on probation, which I don't tend to do for misdemeanors, primarily so that you could pay the substantial restitution, which was over $4,000. There was a plea agreement for a 3-month jail cap. The recommendation of the probation department at that time was that you go to jail for 2 months, for 60 days, with credit for 2 days that you served before. Back at that sentencing, I did not follow those recommendations, and I gave you no jail. I held it in abeyance, right?
That's right.
And then we were back here for a violation of probation. And you had paid your fines and costs, but the alcohol had resumed, it had reared its head. And, you were intoxicated, you had consumed alcohol. Police had to be called to an apartment where you weren't wanted. And at that time, the probation department pretty understandably recommended, hey, you remember those 58 days that you held over his head? Now would be a good time to use them. How many of those days did I give you? None. That's right. I extended your probation, gave you some community service, gave you a chance to continue your substance abuse treatment. And now you violated probation again by committing a crime. It's not a technical violation. You drove while you were impaired. And the probation department, perhaps, being twice gun shy, hasn't recommended a particular number of days to give, because I haven't listened to probation to date. But I'm going to listen to him today, Mr. Brown. I don't, you would not have had to go to jail on this case, but you've really forced our hand to do that. I hold 58 days over your head a year ago when they were recommended. You violate, and I don't give you those days. Perhaps that's my fault. Perhaps I should have given you a little bit of jail then, and Mr. Bloomley's probably nodding his head over there. But I held him over your head again, And now we have a second violation. It's worse than the first one. It's a new crime. You're going to do the 58 days. I'm sorry. So I'm going to revoke your probation, Mr. Brown. I'm going to sentence you to the Presque County Jail for 60 days and give you credit for 2 days previously served.
Your Honor, if they, the Presque County Jail starts having, I don't know if they have yet or not, work release, would the court consider that?
Where's you working?
I work for EH, I guess he's logging.
Mr. Edsbaum?
So we're
Segetsky's logging.
Gauthier logging. Means he's driving a truck all over the place.
I'm on the skidder,
He's on the skidder.
Oh, at that site,
yes.
I would not oppose that.
Okay, work release for standard work week hours will be authorized.
Thank you very much, Your Honor.
All right, Mr. Brown, good luck.
Thank
Let's see who this is.
I gotta go this back to the window. So now,
Okay.
nope.
All right, there's somebody that's come in, but their phone is not. I think it's Mr. Cole again. Who do we have in the courtroom? What's your name, sir?
Justin Mason.
Okay. Let's take that case from page 5. People of the State of Michigan versus Justin Mason. It's filed 21-9316 FC. We have Mr. Mason present in the courtroom with his attorney, Mr. Vogler. Prosecuting attorney, Mr. Radzabon, present as well. We're providing public access both in the courtroom and online. And Mr. Mason, looks like we're scheduled for a docket call on September 13th at 9:30 in the morning. But you're here today on a show cause. The prosecutor is alleging that you're in criminal contempt of court for violating the conditions of your bond by missing several drug tests on May 26th, May 28th, May 29th, May 30th, June 2nd, and June 6th. You have the right to have a hearing on that issue. And where it would need to be proven beyond a reasonable doubt that you are in contempt of court, you have the right to have Mr. Vogler assist you at that hearing. If you are found to be in contempt, I could sentence you to up to 93 days in jail or revoke your bond. I could give you a $7,500 fine as well. Do you understand the rights that you have and the penalties that you can face, Mr. Mason?
Yes.
All right, Mr. Vogler, do you know how Mr. Mason wishes to proceed?
Yes, Your Honor. He'd like to have a hearing, but really to prepare for that hearing, I was informed by Mr. Mason last week that there are other records existing that we need to subpoena with regard to some of these test results in particular. Mr. Mason saying that, for example, on 6/6/7 a.m., a missed test, that he actually tested early, but they're not reporting that on the document.
Well, maybe he's confusing that. This is a, look at the June 6th. Are these misses on the sober link, Mr. Radzabon, or?
Yeah. Yes.
Oh, okay. Okay. All right, well, we'll schedule this then for a contempt hearing. Mr. Radsabon, any objection to setting it for the same time as the docket call?
On August 2nd.
Right, it was scheduled for September 13th.
Oh, yeah, that's fine.
Okay.
Judge, just for the record, since we had prepared this show cause, there's also one more test that came in on July 7th, which showed at 3:01 PM a blood alcohol content of 0.098. So we would add that potential allegations as well. Test 6 more times, 360, 546.
All right, so those allegations will be added then to the show cause for that hearing, Mr. Vogler. July 7th. Positive sober link. All right, and so we'll schedule that for a hearing on the September 13th, same date as the docket call. Mr. Mason, what I want to tell you is, I mean, you're on bond on some very serious charges. If I were you, I would want to make sure I stay out on bond. That means I wouldn't drink a drop, and I would blow every time I'm supposed to exactly in those windows. That's what I would do if I were you. And Mr. Radsabon now with an alleged positive too, I guess I'm going to say you have the right to have a hearing, but we also have lots of issues going on. If there's another positive, I would sign a warrant for your arrest if the prosecutor submitted it, and we would have the hearing that way. Okay. So I don't want you to tell me anything right now about this existing violation, but if you were drinking, no more. If you drink on this bond from this day forward, you're going to sit in jail until your trial. Right? You understand that?
Yes, sir.
All right, we'll see you on September 13th then in person. All right, let's see if we can get Mr. Cole connected here. See who this is. Jasmine Groneveld? There's a Jasmine Groneveld. Do you know who that is? Or?
Yes, she is the mother of our victim in the Mark case.
Oh, okay. All right.
She's here for the motion hearing.
Okay. All right, Ms. Groneveld, I'm not sure if I've pronounced that right. I'm going to place you back in the waiting room. And until we hear that case. All right, well, let's call from page 1. No, actually it's page 2. Oh, I'm sorry. Page 3. People versus Cole, file 21-93177FH. It's for arraignment. So Mr. Cole it's scheduled to be over Zoom. Mr. Cole is clearly having connection issues. He never connected his audio. He's popped in and out on video in a fragmentary way. Mr. Vogler, my thought would be if we continue this to August 2nd and have it be in person.
Yeah, that's fine. I agree with that. That's fair.
All right, so we'll set this for August 2nd at 9:20.
Hello.
Hello, Mr. Cole?
Yes, sir. Are you there?
Let me see if I can send him a message. It's gonna say,
Can you hear me now, Mr. Vogel?
all right, so I'm gonna send Mr. Cole a message. That's because we cannot hear you well. We are adjourning your hearing until August 2nd at 9:20 a.m. in person in the courtroom. Please contact your attorney. All right.
Hello?
No, on your docket, Ann, it had Splitzer, but I think we got a waiver on that, so that's gonna be off the docket. All right, so it looks like our next matter is Amanda Pod, so we'll be in recess until she's here. It's scheduled for 2 minutes from now. Morning, Ms. LaFleche. What case are you here on this morning?
Good morning, Amanda Pad.
Okay, well, you're in luck because that's the case we're calling.
Great.
From page 5, People versus Amanda Pad, file 20-93159FH. We have defense counsel and the prosecutor present in the courtroom, supervising agent on Zoom. We're providing public access both online and in the courtroom. We're here today for a status conference and a show cause hearing for Ms. Pod, who's had a medical furlough from the jail, and it's alleged that she's not complying with her occupational therapy, and that's been terminated, and the hearing is to determine when is it time for her to return to the jail. She was ordered to be here in person, and she's not here. Mr. Vogler, do you have any information about her whereabouts?
I don't, Your Honor.
Ms. LaFleche, do you have any information in terms of an update of her medical situation or suitability for return to serve her sentence?
I do not, she has not provided me any documentation. I've had contact with her and she knew about today's court date.
Okay. Mr. Radsabon, any requests from the people?
Yes, Your Honor, we'd ask that a pickup order be issued by this court judge. I did receive a discharge summary form that was electronically signed June 7th of this year. According to this, she has completed her physical therapy. And while they do recommend skilled home physical therapy, it's our position she could go ahead and return to jail. I don't see the need to continue her furlough medically at this time.
Okay. Well, and what I'll do is I would issue a bench warrant for Ms. Pad's arrest with no bond for contempt of court for not appearing today. And then I guess when she's picked up on that, we'll arraign her on that and then address whether she's to serve her remaining sentence at that point.
Thank you.
All right. Have a good day, Agent LaFleche.
Thank you, you too.
All right, Mr. Martin, can you hear us?
Yeah, again.
All right, so this is from page 6. People of the State of Michigan versus Daryl Martin. It's 2 files. 19-93070 is just a probation violation file tagging along. The violation is an alleged new crime. That's the new file 20-93153FC. We're scheduled for jury trial to begin with jury selection a week from this coming Friday at the Bismarck Township Hall. And then the trial be continuing the following Wednesday through Friday. We have Mr. Martin present from the Prescott County Jail by Zoom video. His attorney, Mr. Vogler's in the courtroom, as is the prosecuting attorney, Mr. Radsabon. And the complaining witness's mother is present in the Zoom hearing as well. And counsel, the courtroom is open. It's a public hearing. We are also providing enhanced public access online. As I understand, the motion today is for witness accommodations.
Correct.
And would require the testimony from a counselor and detailed testimony about a minor witness's state of mental health. Is that correct, Mr. Radsabon?
Right.
All right, so I would propose that we terminate the live stream, and it is still an open courtroom, but we not live stream this hearing. Any objections?
No.
All right, so we're gonna go ahead and terminate that live stream.